movie that's fun and silly and profoundly emotional and impactful, like Deadpool Wolverine in theaters now.
Yes.
I'm working double time, you guys.
Yeah.
I'm double duty.
It's just the best. It's the best. I love it.
Answer: be a fan. Watch movies. Like, you will learn so much from watching movies. Watch movie like it's your job. Sorry, like, you learn by watching movies. When people tell stories, you learn how to tell stories. And
Hey besties, welcome back to my channel. Today we need to talk about something wild. The New York Times, one of the most powerful and well-known media outlets in the world, is making moves in a way that looks a lot like a game of legal chess. And honestly, it's kind of shocking to even say that out loud. Growing up, I always thought of the New York Times as the standard, the gold seal of journalism. If a story made it into the Times, it had to be accurate, right? That's what so many of us were raised to believe. But over the years, we've all learned a tough lesson. No media outlet is perfect, and mistakes do happen. Sometimes they even get things completely wrong. Now, here's the thing. In the United States, it is extremely difficult to successfully sue a journalist or a major media company. And you know what? That's actually a good thing. The laws are designed that way on purpose. They're meant to protect freedom of the press and freedom of speech. Because imagine the alternative. If every journalist could be dragged into court for reporting on controversial topics, our society would basically silence the press. And once freedom of speech starts getting suppressed, that's the beginning of a very dangerous path. Which brings us to the current battle between actor and director Justin Baldoni and the New York Times. Baldoni actually filed a lawsuit against them because of their reporting on a CRD document that actress Blake Lively filed in the state of California. Under New York law, there's something called fair reporting privilege, which allows journalists to report on documents filed with the government, even if those documents are technically confidential or haven't been fully released to the public yet. That's how the Times was able to publish information from this CRD filing. Blake Lively's side, however, later argued that the CRD should remain confidential under a protective order. Now here's where things get complicated. A few weeks ago, the New York Times went to the court and essentially asked the judge to issue what's called a final judgment. They told the court, "We want a final judgment in this case, so that if Mr. Baldoni wants to appeal, he can. If his appeal goes forward, then discovery can begin. If the appeal fails, then everything is finished, and this case can finally be closed. But at this point, we, the New York Times, don't want to remain tied up in this lawsuit any longer." Sounds straightforward, right? But it isn't. See, when the Times filed that request, the other party, Wayfarer, which is Baldoni's company, had 3 weeks to respond. And their deadline to respond was coming up within days, meaning that their counterarguments were about to hit the table. But here's the kicker. To this day, the judge has not issued a final judgment in this case, which means technically, nothing has been finalized. And because no final judgment has been handed down, the New York Times legally cannot ask for attorney's fees yet. They're not fully released from the case, and the lawsuit can't even move to the appeal stage until that judgment comes down. But despite that fact, the New York Times has been taking steps as if they're already free to move forward. In fact, they've been shopping around what looks like a brand new lawsuit. Media outlets have started circulating this so-called filing, but here's the truth. The document hasn't even been officially accepted by the court clerk. It's incomplete. The index number on it is unassigned, and there's even a warning label on the front that literally says, "This document has not been reviewed by the court." That's a major red flag. The county clerk is allowed under the law to reject filings like this. So while it looks like a lawsuit on the surface, legally speaking, it may not even exist yet. Now let's dig into why this is happening. Instead of trying to get attorney's fees approved in federal court, which is where this case started and where the judge has authority, the New York Times has gone to state court. They've done this by filing under a specific statute, New York Civil Rights Law 70-76A, which is connected to anti-SLAPP protections. Let me explain that in plain language. Anti-SLAPP laws exist to stop frivolous lawsuits that are designed to silence free speech. If a court finds that someone brought a lawsuit without a solid legal or factual basis, the defendant, in this case, the Times, can recover their costs and attorney's fees. What the Times is essentially arguing is this: we were sued unfairly. Baldoni and Wayfarer had no substantial legal grounds to bring this case. Because the lawsuit was baseless, Under New York's anti-SLAPP law, we deserve to be reimbursed for everything we've spent defending ourselves. They claim that their reporting on Blake Lively's CRD filing falls under issues of public interest, that they acted within their rights under freedom of the press, and therefore they should not have had to spend enormous sums of money fighting this case in the first place. The district court already dismissed the claims against the Times earlier, and that dismissal came with some very specific findings. The court basically said that to the extent the Times relied on communications not included in the CRD complaint, those statements didn't meet the high legal threshold of being made with actual malice. In other words, the judge did not find enough evidence to prove that the New York Times deliberately published false information with the intention to harm Baldoni. So here we are. The New York Times is pointing to that dismissal and saying, see? The case had no real basis. We won. Now we want our $150,000 in legal fees back. But, and this is important, the problem is that the court hasn't issued a final judgment yet, which makes their attempt to push forward in state court not only premature, but also questionable in terms of legal strategy. The district court went out of its way to point out something very important. The CRD complaint, along with the New York Times article, included a number of messages and documents that strongly hinted the Wayfair team really was involved in spreading negative stories about Blake Lively. In fact, the court said that anyone reading those text messages would likely have little doubt that Wayfair's associates were actively engaged in some kind of smear campaign against her. At the same time, the court also made it clear that the idea of actual malice wasn't supported by the evidence. The court explained that while the Times may have seen certain text messages, those messages weren't enough to prove that the Times acted with reckless disregard for the truth. In other words, while there was definitely negative publicity around Lively, the court suggested that much of that could have been coming from sources other than Justin Baldoni and his team. Even though the article talked about negative claims, it also included context that favored Baldoni, and it gave space for him to respond. The court emphasized that by publishing his denials prominently, the Times actually weakened any claim that it had acted with malice. So, the big takeaway was that the amended complaint just didn't manage to adequately plead several of the critical elements necessary to support a defamation claim. The court also dismissed some of the other claims completely. For example, the false light claim was thrown out immediately because New York doesn't even recognize false light as a valid legal cause of action. Similarly, the claims of promissory fraud and breach of implied contract were rejected as being without merit. The judge explained that no actual contract existed, and at best, what the plaintiffs had was simply an email giving them until noon to provide a comment. That, in legal terms, is not a binding contract. Meanwhile, the Times said that it had racked up at least $150,000 in legal fees and costs just defending itself against these claims. So, their argument here is pretty straightforward. They believe that because they were merely reporting on matters of public concern, using a legal document as their source, while also giving Baldoni space to respond, they weren't acting with malice. And under New York's anti-SLAPP law, that means they should be entitled to attorney's fees. Now, let me pause here and give my perspective. I'm all about protecting freedom of speech and freedom of the press, because those are cornerstones of democracy. But from day one, I personally struggled to understand the strategy of going after the New York Times in this way. Historically, it is almost impossible to beat them in court on a defamation-related claim. That's not just my opinion, it's the reality of how press protections work in the U.S. To me, this lawsuit always felt more like a public relations move than a real legal strategy. Of course, I know that there are people who disagree with that view. Some genuinely believe that Baldoni and Wayfair had a solid case, especially when it comes to how the Times used text messages that weren't technically part of the CRD filing. There are legitimate questions about whether the Times properly and accurately presented the CRD complaint as exactly what it was, a complaint, not a lawsuit. Those are questions that could have been raised more forcefully on appeal, had Wayfair chosen to go down that path. But here's where it gets interesting. This latest filing from the New York Times almost feels like legal gamesmanship. First, it's being promoted in the media as if it's a brand new lawsuit. But the reality is, it hasn't actually been accepted by the court yet. Second, the Times chose to file this in a New York state court, which raises eyebrows. It really looks like forum shopping to me. Basically, picking the court that they think will give them the best possible outcome. And that's questionable. Why? Because in federal court, specifically the Southern District of New York, judges often rule that New York's anti-SLAPP statute doesn't fully apply. And when it doesn't apply, attorney's fees usually don't get awarded. So, if you're the Times, you probably know your odds of winning attorney's fees in federal court are slim. Filing in state court makes it seem like they're trying to sidestep that. But that move comes with risks. Justin Baldoni and Wayfair could very easily file for removal, which means taking the case out of state court and moving it right back to federal court. If that happens, the case could land back in front of Judge Lyman, who handled the original federal case. Since the original claims were dismissed in federal court, this request for attorney's fees is directly related to that case. And under the law, specifically 28 U.S.C. Section 1441, any case filed in state court can be removed to federal court if it could have been brought there originally. On top of that, 28 U.S.C. Section 1367 gives federal courts jurisdiction over any claims that are closely tied to a case they've already decided. What that means is simple. This attorney's fees dispute actually belongs in federal court, not state court. All Baldoni's legal team would have to do is file a notice of removal, and the federal judge could immediately pull it back. Judge Lyman has already indicated in earlier rulings that Reynolds, Lively, and Sloan could seek attorney's fees through a separate motion if they wanted to. So it's unclear why the Times is even trying the state court route. If the case does get removed back to federal court, the judge could deny the motion outright under Rule 54, or apply the anti-SLAPP law more narrowly. Either way, that's probably not the outcome the Times is hoping for. Typically, once a case is dismissed, the party that wants attorney's fees needs to file for them within about 2 weeks of the dismissal. Sometimes, they can also file after a final judgment is issued. In this case, though, the Times seems to be jumping ahead by filing in state court before a final judgment has even been handed down in federal court. That's why this looks like forum shopping to me. It feels like the Times already knows that if they try this in federal court, they might lose. So instead, they're testing their luck in state court, hoping for a friendlier ruling. But if it gets removed back, they're essentially wasting time and money, just piling on more attorney's fees in the process. And here's another layer of complexity. The anti-SLAPP law in New York was revised in 2020, and ever since then, there's been a lot of uncertainty about how it applies in federal court. Some judges have ruled that parts of it conflict with federal civil procedure rules, meaning they can't apply it at all. Others have said certain provisions, like the fee-shifting aspect, can still be enforced. So, depending on the judge, you could either win big or get completely shut down. That means even asking for attorney's fees in a case like this is a gamble. And when you're the defendant, the one asking the court to award you fees, you're putting yourself in a position where the other side gets to argue back. You can bet Wayfair will come back with strong arguments about why those fees shouldn't be awarded. So, to sum it up, this whole move by the New York Times feels risky, messy, and maybe even unnecessary. If they had just waited for a final judgment in federal court, they could have made a straightforward motion for attorney's fees. Instead, by going through state court, they've opened the door to even more legal wrangling, more delays, and more expenses. At the end of the day, it's really going to come down to the judge. He's the one who has to decide whether this request for attorney's fees is actually valid or whether it should be denied. To understand how Judge Lyman tends to rule on these issues, I did some digging into one of his past cases. In a matter called Griffles, S.A.V.U., he was faced with a motion for anti-SLAPP fees, and he ended up denying it. In that case, Judge Lyman wrote in his decision that the defendant's request for fees under New York Civil Rights Law Section 70A, often shortened to 7A, had to be denied. Now, Section 70A says that if a lawsuit involves public petition or participation, then a defendant may recover attorney's fees, but only if they can prove that the action was filed or continued without any substantial basis in fact or law. So, in other words, the law is saying, if the lawsuit was completely groundless, then the defendant might be able to recover their legal costs. That's the exact argument the New York Times is trying to push in this case. They're telling the state court that Baldoni and Wayfair kept this lawsuit going even though it supposedly had no real legal foundation. But looking back at that Griffles case, Judge Lyman explained that the plaintiffs there did have some substantial basis for their claim. For example, They argued that the defendants had failed to disclose a loan in financial filings, while the defendant's report stated multiple times that the loan had been disclosed. That discrepancy, according to Judge Lyman, gave the plaintiffs a reasonable basis to bring their lawsuit in the first place. And since there was at least some basis, he ruled that the defendants couldn't recover anti-SLAPP fees. In fact, Judge Lyman went so far as to say that since he was denying the motion anyway, he didn't even need to weigh in on the bigger issue of whether such a motion could be properly filed in federal court. That tells you a lot about his style. He often chooses not to address controversial issues if he doesn't absolutely have to. And this is where the New York Times argument becomes a little shaky. In their filing, remember, one that hasn't even been officially accepted by the court yet, they're presenting the situation as if Judge Lyman had already determined that Baldoni's lawsuit was meritless. But the truth is, he never said that. When the original lawsuit was dismissed, Judge Lyman denied anti-SLAPP motions from Leslie Sloan and Ryan Reynolds as well, but he did so with a caveat. He left open the option for those motions to be renewed if new information came to light that proved the case was truly brought without merit. In other words, he didn't close the door completely. He just said it wasn't proven at that time. So let's be clear. Judge Lyman has already made decisions multiple times in this case not to award attorneys fees, and when it comes to the anti-SLAPP law, he's carefully avoided making a definitive ruling. Instead, he's leaned on other grounds, like the fair report privilege and the lack of plausibly pleaded actual malice. That means the dismissals were based on protected reporting and failure to meet the legal standard for malice, not because the lawsuit was deemed baseless. This shows us something about Judge Lyman's approach. He tends to take the path of least resistance. If he can resolve a case without wading into thorny legal questions about anti-SLAPP, he'll do exactly that. And honestly, he might just be one of those judges who is reluctant to award attorneys fees unless the case is truly egregious. That might explain why the Times is trying to sidestep him altogether and take their chances in state court. It looks like they know Judge Lyman's history, and they realize their odds of getting attorneys' fees from him are very low. So instead of going through the proper federal process, they're hoping a state court might be more generous. But again, this whole move feels premature and it's risky. Now, what about Wayfair's side of things? At this point, we don't even know if they're going to appeal. They've hired appeals attorneys, sure, but that doesn't necessarily mean they'll go through with it. And even if they do, appeals in cases like this are very tough to win. The legal standard for proving defamation against a major news outlet like the New York Times is incredibly high. Think about it. Even if you don't like what was written, or even if you think the Times blurred the line between a CRD complaint and an actual lawsuit, the court has already said that doesn't amount to malice. And remember, malice in legal terms doesn't just mean bad intent. It means knowingly publishing something false, or publishing it with reckless disregard for the truth. That's an almost impossible bar to meet unless you have smoking gun evidence. So unless an appeals court sees something completely different in the record, it's unlikely this case gets revived in any meaningful way. And right now, there's not even an appeal filed yet, just the possibility of one. Meanwhile, the Times is pressing ahead with this push for attorneys' fees, but they're doing it in a forum that might not even be proper. If Baldoni and Wayfair want, all they'd need to do is file for removal and bring the whole thing back before Judge Lyman. At that point, it's his call. And based on his track record, it seems unlikely he'd award the Times their fees. That's why I think this is a legal strategy that could very well backfire on the New York Times. By choosing this route, they might end up wasting time, resources, and credibility, only to still be denied the attorney's fees they're chasing. So, what do you think about all of this? There are so many lawsuits, so many filings, and honestly, so much strategy involved that it's hard to keep track. I try to stay neutral when it comes to the New York Times, but I can't help but question the decision to push for attorneys' fees in this way. Does it make sense to you that they're filing in state court? Do you think they'll actually succeed, or is this just going to collapse once it gets back in front of Judge Lyman? I'd really love to hear your thoughts. Drop them in the comments below. And before you go, don't forget, if you found this breakdown helpful, give this video a thumbs up, subscribe if you haven't already, and hit that bell so you don't miss my next update. Thanks so much for watching, besties. Until next time,